Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh, and a very good day I wish to everyone who is watching this video, especially to Professor Madia dan Haji Muhammad Shanawi Muhammad Firuz. My name is Muhammad Lutfil Hadi bin Muhammad Najib, and my student ID is 2024284294. Today, under the subject of INC500 Industrial Relations, Regulations, and Cybersecurity, I will be presenting a legal case on the matter of industrial relations involving CHOK versus the Pacific Insurance BERHAD, which take place in 2018. This case touches on fairness in dismissal, the need for proper procedures, and also demonstrates how Industrial Relations Act 1967, or commonly known as IRA 1967, protect employees from unreasonable termination. Moving on to the next slide. These are the facts of the case. CHOK, which is the claimant in this case, was a deputy manager in the policy processing department at the Pacific Insurance Berhad, which happened to be the respondent to this case. So you could say that Madam CHOK, or the claimant, was a senior employee at the company. Claimant, however, was terminated on 19 November 2015 due to three major reasons that were stated on the termination letter. The first one is the lack of leadership skill. The second one is the misuse of company resources. And the third one is the recent case of interaction with ex-staffs who are now working with the competitor. However, the employee also tried to validate her dismissal with a decade-old case that takes place in 2004, which involved a minor incident where she was allegedly making negative remarks about the company. However, neither domestic inquiry or DI was conducted, nor a show cause letter was issued by the respondent on the dismissal. Claimant then filed a complaint under Section 20 of Industrial Relations Act IRA 1967 because the claimant thought that the dismissal of hers was baseless and unfair. She was not reinstated to her former workplace and was awarded with compensation instead. Moving on to the issues of the case, the central issue in this case is whether the claimant's dismissal was carried out with just cause or excuse, specifically whether the employee's reasons were genuine, fair, and supported by real evidence. The second issue of the case the second issue of the case is whether the respondent followed an appropriate procedure. The employer failed to follow basic principles of natural justice, which includes no investigation, no opportunity for the claimant to defend herself, and no due process. And the third issue of the case is whether there was misconduct and misuse of company assets. Moving on to the judgment of the case. The industrial court, however, ruled in favor of the claimant. The court relied on the balance of probabilities to prove the misconduct, aligning with the precedent case in Telekom Malaysia Kawasan Utara versus Christian Kuti Sangguni Nair and another in 2002. Speaking of balance of probabilities, respondent must prove the dismissal was fair, stronger, and credible. Chok's story was more likely to be true after it was presented to the court, compared to the weak evidence that the respondent provide. The court also applied the principle from Goon Kui Foy versus J&B Codes, Malaysian Berhad, which took place in 1981, which states the dismissal of employees must be solely based on the reasons given on the termination letter. In this case, the 2004 incident was not, however, stated in the termination letter, and respondent relied and attempted to justify her dismissal on a very vague assumption that happened in 2004. The court ruled that the evidence provided of the dismissal was too vague and found her dismissal to be just without cause or excuse. The court, however, did not issue a reinstatement, but rather a compensation to the claimant. So these are the analysis and the critique. Uh, these are the analysis and my critique on the case. The claimant's termination might have been biased rather than a genuine decision. The alleged minor misconduct, like photocopying, which she did not use for her personal matters, or speaking with ex-staff, does not appear serious enough to justify dismissal. This suggests that the decision was influenced by prior intentions rather than a fair evaluation of her actions. Second one is the court relied on Section 30, subsection 5 IRA 1967 to focus on fairness and the merits of the case. In the section of 30, subsection 5 IRA 1967, it stated that the court shall act on equity, good conscience, and also substantial merits. This section exists to protect fairness in workplace disputes and give the court flexibility to ignore technicalities, but also to look at the real evidence instead. Furthermore, the case shows why clear documentation and proper procedures are crucial. The charges on the claimant were vague and no proper domestic inquiry or DI was conducted, meaning the claimant here did not get a real chance to defend herself. This indicates that the HR of the company failed to follow basic regulations. Though we all know that domestic inquiry is not mandatory, but such matter could be helpful in proving whether the misconduct really happened. Thus, it will strengthen the respondent case. In precedent case like Muhammad Azizi versus Asian Kitchen, the state negative comments were proven. Yet in Madam Chok Kang versus the Pacific Insurance BERHAD, the state negative comments that happened in 2004, however, was not proven. Moreover, the employer's reliance on the decade-old case should not be presented. I personally think that if the action happened from years ago and the claimant really committed it, then the action should be taken immediately after that. So the employer's evidence in Chok Kang case was weak, outdated, and inconsistent. The industrial court played a crucial role in identifying these flaws and ensuring that justice was served to the claimant. Moving on to the reference of the case, these are some of the precedent cases that are used in order to reference Chok Kang versus the Pacific Insurance Berhad. The first one is the case itself. The second one is Gun Kui Foy versus JNP Courts Malaysian Sedian Berhad. The third one is Muhammad Azizi bin Sohan and versus Asian Kitchen Malaysian Sedian Berhad. And the fourth one is Telecom Malaysia Kawasan Utara versus Christian Kutis Sangguni Nair and another in 2002. And also the Industrial Relations Act 1967 as a reference to the case. Therefore, I conclude my presentation with wabillahi taufiq wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh. Thank you for listening. Goodbye.